Cummins, with some economy of time, do you wish to respond to the last barrage?
Well, only to say that nobody disputes that when a law enforcement is fired upon, that they have a right to fire back. The point is that everything that created that situation was incompetent, unnecessary, and reckless. And it defied the law because, as a former assistant, you know the Fourth Amendment cases that allow either a no-knock or what I would call a tap-and-go type entry with no real waiting for someone to come to the door are only justified by exigent circumstances that do not exist in this case. So in my opinion, as a former U.S. attorney, this was a completely illegal search because of the forced entry and the lack of time they gave the occupants of a fairly large home to get up at 6 in the morning. The law requires them to wait for enough time, for a reasonable amount of time for someone to come to the door and admit them in.
50 seconds.
And I assume the local prosecutor...
My time. Yes. You've had plenty. And Mr. Cummins, I appreciate that very effective rebuttal. Here's what's interesting to me as this hearing evolves. I hear Mr. Goldman defending the practice that he says is engaged in every day. And earlier on, the ranking member invoked the Breonna Taylor episode, and I've just been sitting here reviewing it. Mr. Goldman said earlier on, well, this wasn't a no-knock warrant. Okay, what's the difference in the situation if they knock and they blow in, in 20 seconds, or it's a no-knock? In fact, in the Breonna Taylor case, that wasn't a no-knock warrant. They said they knocked and waited 45 seconds, and they went in. Mm-hmm. Here's something that's interesting. In the Breonna Taylor thing, she was killed on March 13, 2020. In that, it was execution of a search warrant, just like this one.
Murder. The murder.
The first police officer was fired June 20. In September 2020, Louisville entered into a $12 million settlement with the family. Have you been made any overtures by the Department of Justice to settle liability against the government on behalf of Mr. Malinowski's family?
No, sir.
In September, also, one of the police officers was indicted for willful endangerment or wanton endangerment. A second officer was fired in January 2021. A third officer was retired in April 2021. Oh, I left out. In October 2020, grand jury testimony was leaked. Later in 2021, the DOJ indicted 4 officers, and even now it's retrying one who were for the hung jury. I don't understand the difference. I don't understand my colleagues' reaction that
if you would yield, I could share the difference with you.
You've talked for a long time. I'm going to talk during my time.
Okay, then I would tell you the difference.
Maybe you can provide context for your egregious double standard. No one that I recall on the Republican side, when the Breonna, by the way, you said this was interfering in the process to have this hearing. The first time Congress had a hearing was in June 2020 over the Breonna Taylor episode. There was no concern about interfering. The concern was about the use of this kind of tactic to enter unnecessarily and jeopardize people's lives. Yep. Now suddenly that seems to be of no concern whatsoever. Can you account for that difference, Mr. Cummins?
The facts are very similar, although that was a drug investigation, and under the case law, they are allowed to go in faster because of the potential for destruction of evidence.
Yes, so in this case, we're talking about conduct that the law would say is malum prohibitum, not malum in se. In other words, what the reason they entered this residence and jeopardized this entire family, including Ms. Malinowski, who has no allegations against her, and shot this man dead, is because he didn't have the proper license for the business they say he was engaged in. And it's even disputed about whether he was engaged in that business.
Correct.
And in that case, Ms. Breonna Taylor's boyfriend was without any contradiction engaging in illicit drug activity and receiving and deal. He was a drug dealer, and he was carrying it on in her place of residence. I can't account for the gross disparity, except that Americans hear a lot, and I hear a lot back about concern about a double standard of justice. Is there a double standard of justice here, Mr. Cummins, in those two episodes?
There appears to be, and that causes a loss of trust in government and in these agencies.
Mr. Kleckner, the only place I see reaction besides a hearing like this exposing stuff is that attorneys general across the nation have sued over the two rules, the business engaging in the business rule that's at issue here, I guess, really, and the pistol brace rule. Why is that the only recourse that people have state attorneys general file litigation?
I don't understand your question, Congressman. Are you saying that they should be?
My time's expired anyway. We're going to get a new one. I'm run out.
Well, we can give you a chance to, you want to rephrase the question?
Yeah, thank you, Mr. Chairman, if I can rephrase the question. Here's what I'm saying. Congress doesn't seem to be able to do anything to press back against this overreach. At least it hasn't, including under Republican leadership. The only thing that seems to be available to people for the government to do to provide recourse is I see a state attorneys general out filing lawsuits in great numbers, 21 states in one case, 24. Is that the only recourse that people can expect from their government in the response to these kinds of abuses?
It apparently is the only one they have, but it's not what they should expect. We should expect that the administrative agency is reined in a little bit here.
Thank you, Mr. Chairman.
We're trying. The chair recognizes gentlelady from